Hello and welcome to the Inside Risk and Compliance podcast. I'm your host, Adam Spencer, Director of AJ Fox Compliance, a specialist recruitment agency focusing on all things law firm risk and compliance. I have seen so many people carve amazing and fulfilling careers in this space, and it really has been a pleasure speaking to people who enjoy doing what they do every day. However, one thing that has really stood out to me is how hard it can be for people to access the bigger picture outside of their team, outside of their firm. We created this podcast to share with you some of the insights, experiences, and stories of the most interesting people succeeding inside risk and compliance.
In this episode, we welcome back Amy Bell, founder and CEO of Teal Compliance and AML Sorted, and chair of the Law Society's Economic Crime Committee, to talk about the biggest AML reform you've probably not heard enough about, Australia's long overdue regulation of lawyers, accountants, and real estate agents. Amy shares insights from her recent work on the ground in Australia, where thousands of firms are scrambling to get AML-ready for the first time, from the pressure on tiny regional practices to concerns about privilege, resourcing, and even threats from organised crime. This episode is packed with practical insight, cautionary tales, and a healthy dose of optimism about where compliance in Australia could go next. Enjoy. So Amy, welcome to the podcast again. How are you doing?
I'm really well, thanks. Thanks for having me back.
No, it's really exciting to have you back. You've been up to all sorts, and we're going to be digging into that and finding out about that as well. So for the benefit of people who don't know who you are, do you want to give a brief intro to your background a little bit, and then we'll talk about what you're up to now?
Yeah, absolutely. So my name's Amy Bell. I'm a solicitor. I'm qualified in England and Wales. I find myself having to say that now for reasons we'll come on to.
Yeah.
I've been a solicitor for 25 years. In the last 20 of those, I've specialised in law firm compliance. I'm probably best known for my work in anti-money laundering, where I've specialised for the last 20 years, both within the law firm and out for the last 13 years as a consultant to law firms. And I'm the current chair of the Law Society's Economic Crime Committee, brand new rebrand.
Exciting.
It was the Money Laundering Task Force, then we were the Economic Crime Task Force, and now we're a committee. That means in my role at the Law Society, I volunteer there and I help the Law Society with lobbying, with discussions with law enforcement, government, with the SRA on AML issues, and we contribute towards writing the legal sector guidance. So yeah, that's what I do. Awesome. And latterly, I've been all over the globe. Well, 2 places around the globe, but finding out whether what we do here will work there.
Yeah, because we're really excited to hear about that. So for those who are listening who are not familiar with Amy, we've had Amy on the podcast before. So if you want to hear more about her story, the origin story of Amy Bell, then go and check out the previous episodes. We'll link to that in the show notes. But since we last chatted to you, yes, as you mentioned, you've been around the world, but basically as far as you could go to the other side of the planet, because there's been some quite substantial changes over in Australia. So do you want to take us through, what's happened and why are you spending time in Australia?
Yeah. I mean, as my husband says it, the next furthest place to go is the moon from Australia. So, I couldn't get any further away. And
that'll be podcast 3, Amy on the moon.
So, there's a specific timely reason for me looking at Australia, and that is because they currently do not regulate lawyers, accountants, and real estate agents, so estate agents, for AML, but it's coming. So, which when I mention that to people, they find that unbelievable in the UK. They're like, what do you mean lawyers don't have to do it? It's not that they don't know who the clients are, but they have never had to have an AML policy. In fact, one of the things that I've recognised in all my visits, I've been 6 times, clocking up the air miles.
Nice.
Compliance isn't it's not a discipline. It's not a project in the same way it is here. It's not a department in the same way it is here. And I think actually I've also been I did spend some time in Canada checking out what was going on there as well. And I think as soon as you leave the UK, actually, how people do or how people view compliance, how the regulators view compliance, very different once you leave here. And that I think has been, really eye-opening. yeah, and hopefully we'll get into some of those differences that there are.
It's been in the pipeline in Australia for a while, right? Am I right in understanding that? It sort of was coming and going and coming and going?
That's exactly right. The requirements obviously come down from the Financial Action Task Force, which everybody's signatories to it has to do. And if you every 10 years, a country is subject to something called mutual evaluation, an audit, basically, by FATF.
Yeah.
And FATF are coming in and saying, well, these are all our requirements, and are you doing them? As in, have you got them in law? And then are they actually working, whatever your kind of approach to implementing their requirements are? So all countries have one. And the last one that Australia had was 2015, and they had not at that point regulated the lawyers. They were calling them tranche 2.
Yeah.
So it was always the intention to regulate the professions, because that's what FATF says you've got to do. But what they said is, we'll bring out tranche 1, which financial services and gambling, which are arguably much closer to the action when it comes to money laundering than the professions are. And we'll bring in tranche 2 when we get round to it. So the kind of language in Australia is, tranche 2's come in, which means we're going to start regulating the lawyers. So in 2015, the Australian government were criticised for not having brought in the professions. They, about 7 years ago, got quite close, I understand, after that poor FATF visit, but it kind of got kicked into the long grass. Now they're due back, FATF, because obviously they were in 2015. They're actually coming the second half of 2016 to 2017. The report will be out in 2017. They actually were due to come a year before that. I'll be honest with you, I've never had cause to keep a lot of kind of vigilance over FATF dates.
Right.
But I did notice this one moved. And I think it moved because there must have been some diplomatic conversations that were saying, listen, we are not going to be ready if you come between 25 and 26.
Yeah.
So can we have an extra year? But we will get it done, I promise. I mean, I'm surmising that, but that's a possibility of what happened. And that's because Australia, I think I saw somebody that I know, a really great guy called Paddy Oliver, and he was over in the UK when we got AML, and then went over to Australia 20 years ago for AML coming in there, and actually hoping that it was for lawyers, but actually ended up specialising his career in financial services, because most people over there that know anything about AML have been working in financial services. And he said something like the law had been amended hundreds of times. The current AML law has been amended hundreds of times. And the word on the street when they put the first consultation out, so now I'm going back to September 23, they brought a consultation out and said, right, we're going to bring the lawyers in. What do you think, basically, was the consultation. And basically the output of that was, everybody said the current regime is way more complicated than it needs to be. And small, teeny tiny entities will not be able to navigate it. So you're going to have to change it for everybody. And I think that's why they got the extra time, because it's not just the lawyers, the accountants, the real estate agents that now need to worry about it. Actually, everybody in tranche 1 is also having things changed.
Right. Okay.
Which they're going to have to figure out what they're doing as well. So it's a wholesale change. It's a bit like when we got our money laundering regulations in 2017, that it was like, rip up the old one and we get this new one. I mean, the new one, I've got it here somewhere. The new law, because obviously I carry it around with me every day. I mean, I do.
Always got to have it handy. Okay.
This is the law.
Pretty chunky.
Now, this is the Anti-Money Laundering and Counter-Terrorism Financing Act 2006 as amended. So, that's it.
And did they get advice from people in other jurisdictions? And because it sounds like if it was going to be too onerous for small businesses, presumably other countries have been through those challenges.
Yes, definitely. I personally been consulted quite a few times.
Oh, really?
What do you think about this? I found Austrac, who were the regulator. So we have whoever your legal regulator is in the UK will be your regulator. So the SRA or the CLC or Northern Law Society Scotland or Northern Ireland. In Australia, it works differently. The regulator is AUSTRAC, which is the FIU, is the equivalent of the NCA. Yeah. So there's just one regulator there, and they're not legal sector or any other professional services sector specific, or even financial services specific. They're a law enforcement agency, but I found them to be very open, collaborative, curious about what the right way to do it is, and they've kept an open mind, and they still keep an open mind in my view. The conversations, the things that they ask me about, they genuinely are trying to get it right and make it workable for the small firms. But the small firms, like, we can talk about small firms from the context of the UK. We consider a small firm, to be I don't know, a local practice, one or two or even three branch offices locally. We'd class that as a small firm, probably under 50 people or something like that. One of the first things I learned about Australia when I started going was that the shape of their legal sector is very different. So if you looked at the whole of the UK legal sector, you've got about 10,000 firms. There's about 1,000 that you would class as sizable, large to very large. Then you've got about 4,500 mid-size, between, I don't know, 2 and 10 or 12 or 15 partners, something like that. And then you've got your sole pracs, another 4,500 of your sole pracs. Australia, completely different. 85% of their sector is sole practitioners, whereas 45% of ours, 85% are sole practitioners. Now they're going to be
terrified by this then.
Well, you see where I'm going, right? So they've, and mainly that is because of PEXA, of the way money moves through the conveyancing system. Well, it's a combination of two things, actually. In the UK, we've got panel management that allows us to do conveyancing, and we've got open market, commercial market, professional indemnity insurance who have a risk appetite for insuring you to do conveyancing. So the reality is here, most of those 4,500 sole practitioners, most of them don't do residential conveyancing because they can't get on the panels as a sole practitioner. And they can't get insurance as a sole practitioner in case we run off with the money out the client account. Right? Not that any of us would, or hardly any of us would, but that's the theoretical risk. In Australia, money for completions doesn't move from solicitor to solicitor. It actually goes into a big pot that's managed by PEXA in the UK as well. And PEXA will distribute the money all over the place. So the security about it, because it's not in the solicitor's trust account.
Sounds like that makes a lot of sense.
Well, it's to speed things up. Instead of what we do in the UK is wait for the money to land across the whole chain. Like, it's all going into PEXA. The lenders aren't concerned because it's going into PEXA, and people are not as concerned. So people can move quicker. Basically, the money moves around the system a lot quicker, and that, I think, is the ambition of PEXA here in the UK as well, to be able to bring some of that learning over here. So that what you will have in Australia, the reason there's so many sole practitioners, is number one, sole practitioners can do conveyancing. That's why there's so many of them that are going to be in scope of the regs. And secondly, it's just a geographical spread. Now, it is true 75% of the population of Australia and the legal sector in Australia is down the East Coast, down the kind of Queensland, New South Wales, Victoria. But there's a massive territory. It's like just huge. Australia is like mind-bogglingly huge if you're from the UK. I cannot compute. And so, you do literally use the flights from, Melbourne to Sydney, which would take you 8 hours to drive. It's just like jumping on the train to somewhere. It's an hour to Leeds from here. It's just like that. It's just, you start to kind of start
it's a
to
different
adjust
scale, isn't it?
It's huge, right? And so you've got all of these teeny tiny towns where they've got they need lawyers. They absolutely still need lawyers, but what they probably have got are these kind of more general practitioner lawyers. So, when you go and see your GP, he's got to know everything about all kinds of different bits of medicine. It's a bit the same about your GP lawyers in these smaller places. So they might only do 3 conveyancing transactions a year. They might do 7 wills. They might do 4 divorces. They're so like multidisciplinary practitioners, which we don't tend to have in the UK. But because if they just do 1 or 2 in-scope things, then they will be caught under this regime. People are like, this is going to be expensive and difficult for those small firms. And it is. I was kind of expecting it to be a bit like the 10-45-45 that we have here. And when I went there and realised this about the money, I said, well, how am I going to help these people? Bless them. Honestly, and completely honestly, I'm giving away my commercial secrets here, but not many sole practitioners knock on my door. We get a few, but generally, because they often participate in work that's completely outside of scope, and that's all they do. So here, a lot of the sole practitioners will be family lawyers, or will be litigators, will be criminal lawyers. They're not in scope here, whereas the teeny tiny firms there are. And to set up a program, which is what they're going to have to do, is really expensive comparatively when you're a sole practitioner.
What's the sentiment over there about this then, from that portion of the legal sector? Presumably, that's
a really interesting question. So I was just on something this morning doing a webinar for one of the law societies has booked me. I'm doing I've built a free webinar series for firms out there, and they booked me to run it for them. And I was chatting to them, and there's such a lot of conversations still about, is the work that I'm doing in scope, as in people are looking for an out. They don't want to do it. How can I figure out how not to do this? And I think historically, it's again interesting from my travels in Canada. When I went to look at Canada as a potential place to go and expand to, we won a place on a government-funded scheme for international expansion. And into Canada, we were in like an accelerator program for 6 months. And out there, the Canadian bar has been quite successful at kind of keeping people away from lawyers. Privilege is pretty strong, and their law is built in a different way than our law, and so there isn't actually a huge amount of activity going on in AML there yet. I think the FATF effect will eventually, generate more work there, more activity there. But at the moment, it's quite strong. And this privacy argument, this privilege argument, and the privacy one, the privilege one has been one that in Australia they were using to hold it all off. And I think that a lot of the profession got a message directly from the Law Council and lobbying that you can't make it work here, it won't work here because of privilege. Well, of course, in the UK, we know it can work with privilege. You still respect privilege, but it doesn't mean you don't have a programme and you don't try not to work for baddies. A lot of the mindset is still stuck in the messaging that people have had, which is don't worry, they'll never be able to do it here because of privilege, which of course isn't right. And so I'm hoping, there's quite a long lead time. So the 1st of July next year is when it's in force for lawyers. So the law's already out, it's been passed. They're currently working on our equivalent of the regulations, so their rules that go with it, which provide more flavour to the law, and then they'll be working on guidance. But the teeny tiny firms, actually, the regulator, they call them mum and dad firms in Australia. So those kind of, it's me, my family run little business kind of thing. The regulators promised to bring out some starter packs, they're called, which are templates, I think. Which they're endeavouring to bring out. And I just heard this morning they're going to bring them out in consultation the next few weeks. And the reason that they're doing that is because, there's rumoured to be about, numbers vary, between 70 and 90,000 new entities that are covered by these changes that are brought within scope. So if you look at the UK legal sector, there's only 6,500 entities in scope. In Australia, straight away, because of that PEXA, small firms can do conveyancing, there's 12,000. Then you add on all the real estate agents and all the accountants on the top of that, and precious metals and stuff. There's 100,000 new entities are expected to enter the market or be covered. So it's just huge. And I think that for some small businesses, like a small real estate agent who just does one kind of thing, or potentially a conveyancer, so they have law firms that are solicitors, but they also have conveyancers that are not the same. We call solicitors that do conveyancers here. That's not how it works in Australia. Right. There's a lot of this stuff you gotta know. I'm so grateful for all the people that have taken the time to fill me in.
Yeah.
But in Australia, they have conveyancing firms that are separate. Now, if you're a conveyancing firm and that's all you do, you might be able to pick up one of these starter packs that's built for you. But if you're a multi-service, multidiscipline law firm, as in different types of law, I find it really hard to think about how they could write a template, given our UK experience of people trying to do templates and then ended up being disciplined. I just find it really hard to think, especially because these firms, because they will take anything that comes in, because they are serving a community rather than a particular practice area of law. It's how do you know what you're going to have to do?
Do you think that will change though? Because if we're seeing this as this is going to have an impact on bottom line, just a cost right at the moment, and presumably it sounds like some of those small practices only do a small amount of work that is in scope, and it might just be easier and cheaper to just say, I'm going to push that work away, or is it integral to what a lot of these firms do?
It's really hard to say, isn't it? Because, why does the high street here do conveyancing with all the risks and the expensive professional indemnity insurance? Well, they do it because of the cash flow. It's quick turnaround work compared to a divorce or compared to a personal injury claim or something that has to go through the court system. So it's cash flow. It's like cases churn. So this is why you will often see firms that will be carrying not a very profitable conveyancing department, but it keeps footfall, keeps people coming in, that kind of stuff. I have been asked that question quite a lot in Australia. Will there be some consolidation? I can foresee that in some of the smaller areas there might be some kind of agreements where someone goes all in and goes, right, I'm going to do the conveyancing, and I don't want any of this other work because I'm going to have this influx, and you're going to pass me your conveyancing, I'm going to pass you personal injury or whatever it is. So theoretically, it's possible. People ask me about it a lot. We didn't really see that here, but of course, it's a different size and shape of sector here. So that remains to be seen. The costs, and really what they've got to do is learn how to do a firm-wide risk assessment, learn how to write policies and procedures, train their AML compliance officer, that's what they're called, the equivalent of the MLRO and MLCO mashed together, train the staff, and then figure out how they're going to do CDD. It's a lot of time. It's a lot of work.
What's it with the AML-CO? What's the deal? Is it the same, liability for that individual? There's
no criminal liability in Australia, thankfully. It's just financial. Right. No one's going to prison for it unless they're actually money laundering. And also, they don't have DAML, so they don't have to wait for AUSTRAC to come back to them after they've done a report. They still have a reporting obligation, but doesn't get in the way of them doing any work, so they don't have that kind of same issue that we have. They also have privilege protection. You don't have to report anything that's privileged, but not everything that we know about a client or someone we're suspicious about is privileged. And so what's going to be a real challenge there is part of I'm not going to say that lawyers in the UK are not respecting privilege, but in the UK, you've got, if I get this privilege decision wrong, I am facing up to potentially 14 years in prison if I get it wrong. And so we are not splitting hairs over it. We're like, okay, we'll give you as much as we can give you. You've got in Australia this, you can't participate in this regime because of privilege for the last 15 years. And then you've got, there's no threat of going to prison, but you've got regulatory threats if you do breach privilege. And so people are trying to get their heads around it. And I think for the first few years, that's going to be the hardest bit as they try to understand the relationship between a missing piece of paper in client due diligence and whether that's a reporting obligation. And if it is, what we actually tell them, that's going to be really hard. I don't think in the UK, actually, most people involved in AML actually know that because their roles are separate. AML is sitting with the MLCO these days, whereas the reporting and the gymnastics around the privilege and all of that is an MLRO job. In Australia, they're put together automatically, those two roles. And I think that goes to the challenge for resource in Australia, because suddenly you've got 100,000 entities that need to have an AML-CO.
Are there requirements on the background of that individual? They don't have to be a lawyer or anything like that. Is it the same as over here? Or?
No, it's not a lawyer. It's a great question, though. They have to be a manager in the business.
Okay.
They have to be a management level in the business, and they have to have unfettered decision-making and access to information and resources to be able to do the job.
And presumably that's quite a sort of, I mean, the manager thing, do they have to have been a manager before? Or if you call your AML-CO a manager, then it's not really, it's done, isn't it? Right?
That is exactly the conversations that I've been having with the larger firms while I've been there. I've been trying to build teams and going, who do I want?
Yeah.
And when the legislation first came out, when this came out in draft, there was a book nearly this big, probably about half this big, about that big, which was explanatory notes to the amending legislation. And in there, they cover off this piece about who should it be. And you know, bearing in mind, as ever with AML legislation, it's not just written for law firms or accountants, it's written for banks. So that management level is kind of directing you to someone relatively senior in a bank infrastructure.
Yeah.
But in a law firm, and it does go on to say this, it says in a small firm, that's probably going to be an owner.
Right, okay.
Now, my advice to those firms that are larger, that have maybe got an exco and you know, may or may not have a risk committee because no one's ever asked them to have one. There's no cold coffers in Australia or anything like that. So you're trying to figure out what to do. You want to buy someone in who's got AML experience. The reality is that the people that are in Australia, there's very few of them that have got AML and POCA experience. So they've got AML and suspicious circumstances reporting experience. Because in a bank, in a financial services environment, they are completely different career paths. This one's about suspicion. This one's about CDD.
Interesting.
Different things completely. Now, of course, we do train the CDD people to be aware of red flags when they're doing CDD, but privilege, this business of am I actually breaking the law if I don't make this report, is not anything they'll be familiar with. And the reality of someone sat in that position, in the reporting position, is they've got to, in my view, have sufficient authority and autonomy to potentially report the firm's most valuable client to the police. Now, if you're going to recruit someone in with 7 years CDD experience, who was not a manager, who was not an owner of the business, how comfortable are they going to feel saying, I think we need to report our best client to the police?
It's difficult,
not at all. And they're probably not going to be able to act with independence and without influence of the partners of the business who go nuts about that. On the basis of a suspicion, which is, you know, we'll see what their test is. But in the UK, of course, we know it's a possibility more than merely fanciful. It's hardly anything.
Right.
We don't know that they're a crook. We just suspect they might be. So for me, I don't see how it can work, really, in a law firm, having that reporting responsibility, sitting with anyone less senior than a true head of department, if you've got a proper compliance department, but that sits at, you know, comes to partners meeting as an influence into the strategic direction of the firm and that kind of thing, or equity partner. I just don't see how they can do it. I can see probably lots of people ambitious that they could do it, but they were. What I'm worried about in Australia is that because the firms there don't know what they don't know about recruiting, they might not be asking the right questions.
Yeah, absolutely.
So similarly, someone with 8-10 years experience in CDD will be brilliant at hunting down, you know, and know exactly what to do now. BVI has been put on the grey list. They'll know exactly what changes to make, and they'll know all of that. But if you give them this and say, please write me a policy, there's no way they're going to have
it's a different skill set, isn't it?
Writing a policy, because in a bank it's just given to you. You know, it's been there forever. A lawyer, somebody in a law firm is going to have to sell this to all the partners and all the lawyers is going to need to know the law upside down roundabout. I mean, I'm sure no lawyers listening have ever had this happen to them, but it happens to me. Show me where it says I've got to do that.
I just wanted to take a moment out to thank our amazing sponsor, the International Compliance Association. The ICA are the leading professional body for the global regulatory and financial crime community, offering professional qualifications, world-class events and training. Go check them out online, and if any of the certificates or courses take your fancy, then you can get 10% discount using our code AJFox10 at checkout.
And presumably, if it's going to equity partners as well, I mean, they're immediately in a sort of position of conflict, right? If they're going to have an impact on their own earnings, and if there hasn't been, there's not the history over in Australia, right? So there's not the same. I'm really interested to know if there's the fear factor that I guess we've got over here a bit, having seen fines, left, right, and centre, or whether there's a risk that people won't report on their own clients because of the fee income impact.
So I was in Melbourne at some secret squirrel drinks. So some guy who I can't name, because he wanted me to keep it a secret that who he was, but not that the thing happened. So they've created this kind of secret squirrel MLRO,
Safe
CO
harbor,
equivalent networking group, which revolves around going to this really great, British style pub in Melbourne.
Brilliant.
And so I went there, and of course, everyone I met pretty much it was from financial services, because the industry hasn't got going for legal services, or it's starting to get going, but it's not massive yet. And so one of them said to me, "What are they going to do about the bikie gangs?" Okay.
Right. Okay. So intrigued where this is going.
Right. What are they going to do about the bikie gangs? He said, "I'm really worried about the small law firms, because up until this point, as long as the biker gangs and their family haven't brought in more than $10,000, they've not really needed to worry about it. But they're in such small places, they know the biker gangs. And see, in Australia, the biker gangs are notorious for being the hubs of drug dealing.
Right.
So he said, I'm really worried about it, because now they're either going to have to ask for CDD on the money from the biker gang, or they're just going to want to turn them away, at which point the biker gang knows that they're onto them. And what if the gang come in and threaten them? You will do this work or else. Now, in all my years in the UK, no one's ever come to me and asked me that. I have had incidents of people being threatened by crooks in the UK. It's very rare. Very, very rare, but I have seen it. I have seen where law firms have got a panic button installed after doing a SAR and things like this. Yeah, because law enforcement's expectation is just report it and we'll protect you. You can't get out reporting it. And so this was, someone from a bank says, I'm really worried about this for these people, because they're in the community. And I said, do you know what? I think it's even worse than that. In Australia, there's quite a big cash culture. Now, I'm not casting aspersions on Australia without foundation, and I'll give you the foundation. There's a book written by someone who's now a friend of mine called Patrick Lynch. Nathan Lynch, sorry. Patrick's another guy, he's also a friend of mine. Nathan Lynch, he wrote a book called Lucky Laundry. And Lucky Laundry, he's ex-law enforcement and he's now a journalist in AML, in money laundering. And he wrote a book exposing basically what Australia's money laundering problem is. And it kind of goes to the reason that it's taken them 15 years to bring it in later than the, probably more now, since that was 2006. The reason it's taken them so long to get organised with the lawyers is nobody really wanted to do it. There is significant potential for economic disruption as a result of interrupting the flow of into Australia. Australia's got a really amazing, it is an amazing place, but it's also had a really amazing economic history. The same as here, when you go over there, you're hearing about cost of living crisis and all of this kind of stuff. And people were hit through COVID and lockdowns, and there was I think Melbourne had the longest lockdown of any country anywhere ever.
Wow.
Yeah. But Nathan talks about this phenomena of new build properties being bought up with foreign money and being left empty. And it is like, it's obvious when you're there.
Yeah.
And the kind of rationale for tackling this is that ordinary Australians struggle to get on the housing market because of the lack of affordable property, because property prices have been pushed up by foreign people bringing in money and spending it. So I've heard multiple conversations about people going along, trying to buy a house, going to an auction and being outbid by an agent on behalf of a foreign investor, potentially a Chinese investor, who is not even there and is paying, 70-80% above list price just to get the property.
Wow, that's crazy.
It's crazy. Charlie and I, not Charlie, Daisy. I took Daisy with me last time, my youngest, and we were there for 5 weeks. And for a few days, we were in one of my favourite places in Melbourne, which is the Docklands in Melbourne. And opposite, it's in the Docklands, and there's marinas everywhere, and it's really interesting. It's a really nice place to look out the window, and you can see the cruise, you can see the cruise ships when they're there in Port Melbourne. You can see the kind of day trippy boats coming in. You can see big tankers and everything, and you can see these yachts. And then there's this row of houses. Now there's 50 of these houses. There's 25 on the waterfront, and there's another 25 behind them. So we could see these 25, and we conducted a survey, Daisy and I, every evening to see how many were actually inhabited. Now these are minimum $2 million waterfront homes. 3 out of the 25 we could see had people in them.
Wow, it's so funny. I play the same game. My family are in Oxford, and so I regularly drive from London to Oxford, and we go. I'm really bad with geography. We go over one of the main bridges in London, and there's the huge, really fancy, flats. Me and my wife play this game, which is if you can spot any human activity going on inside a single flat, even if it's just a TV flickering, you get a point. And no one's ever scored. We've not scored any points yet. So, and that's like 5 years of going back and forth.
Same there. Obviously, the UK has been criticised for accepting, Russian money into the UK, and there's quite a lot of Chinese investment into the UK. Not to say all Russians and Chinese people are laundering money, of course they're not. But there is reputedly money laundering going on, and is it finding its way here? If you listen to Transparency International, they'll say definitely it is. And this is what Nathan's saying in his book. He's saying this is nobody's wanted to look at this too, because here's the thing, just it's basic economics. I have got an economics A level, who knew? You restrict the supply of that money into the country by doing client due diligence at the point of entry, as into the point it enters a transaction at the lawyer stage. Okay, you start discouraging or disrupting that flow of money in. What's going to happen is there's not as much money coming in for the properties. What happens then is the property prices will drop, supply and demand. There'll be more houses available, and in theory then ordinary Australians, legitimate, honest, hardworking Australians will be able to buy properties at more affordable prices. The only problem with that is that anyone who is on the housing ladder domestically in Australia is likely borrowing quite a lot. And quite highly leveraged. What you don't want for the wider Australian economy is a whole negative equity situation where people stop spending. So, from an economic point of view, I'm not saying they didn't do it because they don't want to disrupt it, but I think Nathan might be trying to imply that in his book, is that the worry is what will the cost be to Australia's somewhat lucky economy if we start disrupting this. Now, here's another question that I've been asked and was never asked in the UK. Does it actually work though? Will it actually disrupt it? Well, who knows? Who knows? Like I say, you can't survey the baddies and ask them, can you? How much money laundering have we managed to frustrate since we brought in CDD? They're not good. I mean, how would we even contact them to ask them, But it's an interesting conversation. Like, you've had this for 20 years in the UK and you've still got this massive problem with it. Does it actually work? That's a really fair question, I think.
It's crazy.
Will it actually disrupt the housing market? Will it actually make properties more affordable?
It's amazing to hear all this, because it's interesting. I think if you're stuck in your echo chamber of just doing some CDD, you don't see the bigger picture of, it is an enormous impact on a country to bring in this regime. So one of the things I was interested in is, obviously we've got a jurisdiction that now is needing skill sets in legal, in accounting, in real estate, and they're not there presumably. So what are you seeing the bigger firms do? What are you seeing businesses do over there? Because the experience they need doesn't necessarily exist yet.
Well, firstly, the thing is, I'm trying to get the message out that the experience they need doesn't necessarily exist, because there's a lot of people in financial services and bank and gambling, CDD staff.
Yeah,
I did a webinar for somebody out there to advise people thinking about looking at the tranche 2 entities as a career change, career path, of why it's different. So I recently, 12 months ago now, actually, I wrote a full day analyst training course. Kept getting asked for it, so I wrote one. And the first cohort I delivered it to was mixed between 50% of the people that were paralegals that had been working in the law firm in kind of file opening, admin-y type activity, conflicts as well. The other half have been in financial services and were coming over to law for their first job, so they knew some CDD but didn't know law. The first thing that I had to teach was how a law firm works, how law works.
Yeah.
I was doing another gig with someone come over from financial services into a law firm, and we were doing some coaching. I was doing coaching for about 6 weeks, twice a week. We'd jump on, we'd look at the inbox together, and we'd figure out what was a problem, what wasn't a problem. And one of the really interesting experiences I had when I was doing that piece of work was there was a conveyancing transaction, and he said, "Oh, Amy, I'm really worried about this one. I think it's suspicious." I said, "Why?" He says, "Well, there's 3 purchasers." Okay, I said, "Right, why?" He said, "Well, 2 of them have got the same name. I don't understand what's going on." So I said to him, "Is there about 20 years difference between the ages of the people with the same name? And are the people that the older people, are they in the 50s, 60s? He's like, "How do you know that?" I said, "Because they're putting the child on the house so they can't take it for care home fees. But unless you know how law works,
you wouldn't have picked it up.
You wouldn't have known it." And so this is the detail I'm talking about.
Yeah.
The reality is, that there is experience in CDD, but it's unlikely to have all of the skill sets that we'd be used to getting here with a good AML manager, which includes understanding the guidance, understanding how to apply that in practice, and then getting onto the CDD. New Zealand went 6 years ago, so they got it in 6 years ago. So there is a lot of transfer of people, and of course there's no visa issues to go from New Zealand to Australia. So there are some people turning up in the larger firms that have moved from New Zealand into Australia. There's a few consultants that are out there as well. The larger firms are thinking about doing firm-wide risk assessments. So we're doing a firm-wide risk assessment for one firm. I've got another firm who's starting to think about socializing their partners into this so their partners understand.
Yeah.
I have advised them that, in my view, for the reasons we've already discussed, that I think that they need to be nominating partners to get encyclopedic and then bring in managers behind them, get some support with writing the policies. I would say that, wouldn't I? But, I do know that picking a template up, even a quite complex template, takes some time. You've got to have some background to understand it and which bits are relevant for you and which bits aren't. The other interesting thing about Australia is their employment rights are different.
Right.
So in Australia, the mandatory pension contribution is about 3 or 4 times what it is here. There is no kind of employment rights start straight away instead of after 2 years of service. The whole 6 months probation, I can pay you off in a week. That really isn't a thing either. So if you make the wrong hire now, and it takes you got to go through a performance improvement process to exit that person, you are going to be right up against the deadline by the time you recruit a new one. So I'm really trying to say to firms, let's just think about this slowly, carefully. who, you need somebody who's going to know whether the person you bring in is doing the job properly or not. So that means you need someone senior with that AML-CO role with enough learning to know what you're expecting in terms of output. There are some people, interestingly, it's you might have noticed this yourself from the people that you work with, but there has been a long-standing relationship between young people coming over from Australia and using experience in the UK as part of their training to qualify when they go back to Australia. And a lot of CDD people I've met over the years, Australian ones, have got here for that, and they've been doing CDD. And then maybe qualified later on as a solicitor. These people, I think, make ideal hires for this role, or ideal nominated people for this role, because they've been used to working in an environment in the UK where CDD was a thing. So they're going to understand a lot more, someone who's completely fresh to it, what the impact's going to be on the clients. I've just done a webinar this morning, 6:30, as I say, 7:30 actually, I'm doing a lot of early mornings these days, and I'm not a morning person. Anyone who knows me.
I try. I can't make it stick.
Not before 10 o'clock. But anyway, so I was doing this webinar this morning, and that was one of the things I was talking about. A lot of people are saying, well, is what we're doing really in scope? Or is only, how much of our work is really in scope? And I'm saying to them, in the larger firms, well, you might consider that difference to be academic. And like, why would we do that? And I'm like, because compliance is easier to manage. If you have one way of doing things around here that applies to all clients, that is way easier than worrying about some people not picking up work that's designated.
Right.
Because it works a little bit differently here. We are a regulated business. We are exposed to the regulations and the reporting, the regulations when we do regulated activity, but we're always exposed to the reporting obligation regardless of whether we're doing regulated activity here. So if you were a litigator, now there's loads of safeguards that might mean you don't report when you're a litigator, but there are, you still might. And that'd take me at least an hour to explain, but just take it from me. Whereas in Australia, you don't have a reporting obligation unless the work you're doing is designated. So basically, as soon as you open a file that is designated, the whole weight of the legislation comes down on you. But if you're not, the rest, so at 10 o'clock on a Monday morning, you could be doing designated services and in scope, but by 11 o'clock, you're back out of scope because the work you're doing then is not in scope. Managing the compliance of that, helping people who are completely new to AML understand when to switch that on and off, that is tricky, and it's put outside my personal risk appetite. If I was running AML in someone's program, I'd be like, no, we'll do everybody because it's easier. But if the file is open, then I know they've done it, and it doesn't matter where that client turns up after this. We know we've done it.
It's a huge challenge, right? I can't imagine with people trying to get to grips with a new regime without the skill set in the country, but also having to hire people without necessarily having the skill set in the business to assess those people. But one of the things I wonder whether you could bring to life, maybe for anyone who's thinking about Australia or who is in Australia thinking about getting into this space, is I imagine most people won't understand why working in risk and compliance could be so exciting right now in Australia. So why does this all make it an amazing time to get involved in it?
Well, now, it kind of goes to why I was there. Listen, I'll be honest, and no offense to any Australians who are listening to me. I never thought I'd have cause to go around the other end of the world. I'm like, it's a long way to go. Now it's a commute for me. I'm like, I'm off on my long commute because I go there so often. But, there was a time where I'm like, I don't even think I'll ever go on holiday to Australia. Why would I go to Australia? As soon as I got to Australia, like literally the first trip, I went, I get it now. I get why people would love Australia. I'm not being paid by the tourist board or anything like that. But it's from coming from a country like the UK, from, deepest industrial Manchester, as you can see out my window, where everything's crammed and everything's like piled on top of each other because of the size of the territory, to go into Australia where everything, there's just, there's a feeling of space. There's a feeling of, I can breathe. It's a much better climate most of the time. A Sydney Sydney winter is just like our summer.
That's
if I'm
mad.
honest.
Yeah, that's crazy.
It's crazy. You know, Melbourne a bit worse, but it's just got this space. It's got also this kind of it's just a generally exciting place. Everyone sees opportunity and sees excitement. It's multicultural. It's certainly in the cities. It's very diverse. Has a lot of Asian influence. All of everybody's having ramen for lunch. I mean,
I love a bit of
I don't
ramen.
like
I
ramen.
love a bit. Do you
Not
know?
one for me.
It's my favourite.
Sushi, all
Yeah.
it's just very, very open. I found people are super generous. Oh my goodness, people are so welcoming, so willing to take time to have a chat with you. It's just so far anyway, it's been such a friendly place. We've just actually taken Rhiannon out in our team. She's just signed for 6 months secondment in Melbourne.
Amazing.
I reached out to some of my contacts there. I've got Rhiannon there. I can't be in Australia at the moment. Can I introduce you to her? So she's got someone on that side of the world, on that time zone, that she can chat to. And no problem. I think they've got 2 dinners and 3 lunches coming up this week in Sydney. Just everybody's really, really excited, about life in general. And then you get AML. Okay, so, I'm not going to over-egg the pudding. One thing in Australia is I have to check that all of these sayings mean something now when I say them all of the time. I'm like, does that mean, is that same down here? I have to check all that all the time. But I won't over-egg the pudding. It is going to be a tough gig in Australia because, when I started in AML, which was 2 years in, I would go out and I would go and train people. I used to do training for the Law Society, and I would go out to smaller firms, at least for the first 8 years, I would say 8-9 years after I started, I would still get people wanting to argue with me in a training session. Why do we have to do this? It's outrageous. We're not the police. I mean, I get them occasionally these days, right? But generally here, most of us have gone, okay, it's the cost of doing business. We've got to do it. And hopefully some of us are, and it's the right thing to do to stop baddies. Over there, we've got to get everybody in a place where they unprogram what they've heard about. It's absolutely outrageous privilege, and reporting our clients to the police is outrageous, which is where we were 20 years ago. We have to get them past that, and then we have to get them into, and now this is how we're going to do it and how we're going to do it well. That period of time is going to be rocky. You're going to need to really sell it. You have to, sell it. Fear does sell. I hate selling on fear. I really hate it. But, people will be. I've got clients that I'm doing proposals for now. I don't want them not to be anyone to help me. So please, can you give me a price now so I can get it locked in?
And what is the fear now? Are there fines that are defined, or is it all unknown?
Fines. It's not like a percentage. How it works is you get so many points, and those points make fines, not prizes.
Points make fines. Brilliant. Okay, so you don't want points. You want 0 points.
Yeah, exactly. So, and then there's the whole regulatory consequences, which we won't see. What we see in fines in the UK is the regulator, who's also our regulatory regulator, issuing fines for breaching the code of conduct. If you look at any of these agreed decisions, they're all about code of conduct breaches and not actually fines, criminal fines under the money laundering regulations. But this will work differently. What we do know, I think, in Australia is that, as I said before, AusTrack is sensible, pragmatic. It's a joy to deal with them. They're really trying to do the right thing and be as helpful as possible. They do understand that to move all of these entities into the regulated sector is going to take time for them to do it. If a firm is trying, I would hope that they would get more good grace than perhaps a firm in the UK that's had 20 years to get it right and is still not getting it right. So I don't think we should be kind of over-egging in terms of potential disciplinary action in the early days, especially for the small firms. I think the larger firms, that'll be different. I think they will expect the larger firms. And of course, and not that I would do this. But if I wanted to make an example of somebody, I'd go after a big firm and give them a big fine. That's where I would go. So whilst there is a line, the other thing about Australia is that their audit regime is compulsory. So in the UK, it's size and nature. It's subject to the size and nature test, and it is required to be done regularly.
Right.
In Australia, it's mandatory for all reporting entities every 3 years.
Interesting. Okay.
So, and then what happens is annually you have to do a report, a bit like the data gathering exercise that the SRA do, but AUSTRAC have one. And I understand under their current enforcement strategy, it's from the people who don't respond and file that annual return, or there's concerns in that annual return, is where the resource for knocking on doors goes.
Yeah.
So yeah, we'll see. What I understand from New Zealand, which is obviously not that far away from there, and is also a growing and maturing AML environment in professional services. After their first lot of audits, that's when everyone started to get in trouble because they'd taken templates or whatever, tried to do it. They got audited. The auditor said, no, not good enough. And that's when all the activity started. And if I was a regulator, that's when I'd be starting to look. So I think there is time, but that year will pass.
It's going to go so quick, isn't it?
Yeah, so quickly. And if you're a smaller firm and you want help, there's only a limited number of us. That's why we're there.
Yeah.
Because we've now created services that are financially accessible for smaller firms.
Yeah.
That we've had to develop a load of software and stuff to do that, but we've done it now. And so hopefully the small firms can benefit from specialised consultancy support as well as the big ones, just delivered in a slightly different way.
Absolutely. Well, it sounds like a super exciting time to get involved in the space if you're over there or thinking about going over there. It's amazing. It sounds like obviously other side of the world. So now Amy Bell is providing AML advice 24/7, it would seem, non-stop.
I think you might find Amy Bell was already providing AML advice 24/7. But yeah, I mean, we had to open a different brand.
I saw. Yeah.
Out there. But in Australia, Teals is a thing. Every time I went to a meeting and said, hi, I'm Amy from Teal, they'd be like, oh, you know about the Teals here, don't you? And I'm like, no. So my pal, Paddy Oliver. So basically, there was a load of the equivalent of their Conservatives, so the Liberals, that had blue party colours, and they resigned the party and ran as independents instead in not this election that's just gone, the one before, but they also ran in this one. Because the Liberal Party, they felt, didn't have a high enough priority green agenda.
Right.
So their blue party colours with a green agenda makes Teal. So they've been funded, like they're not a party themselves.
Right.
But they're all grouped together as the Teals. And so I'm like, I'm going nowhere near that.
Have to abandon that name straight away. You got to do what you got to do.
Well, it's still the same Teal colour, it's still the same, down to earth, sensible advice that you get from Teal. But yeah, it's AML Sorted is our brand over there. It needs a new website, new LinkedIn page, everything. But at least we kept the same colour. So I don't need a new wardrobe.
we'll put your details in the show notes, and if anybody needs some advice, then obviously you know where to reach out to. Amy, that has been so fascinating. The last question is, where's next? Are you going to be able to convince Trump to change the AML regs in the US?
Well, you know what? I don't think anyone can convince Trump of anything, if I'm honest. Or if it is, it isn't me. Australia are one of the last 5 jurisdictions covered by FATF that have gone within scope. It's really China, and even China's moved, and China has got regulation of lawyers now. So Australia really is the last big place. America is the last big place, like an outlier. So we'll see when they have their mutual evaluation what happens. So if you don't know what happens with mutual evaluations, if you do get a poor report, that's when you end up on the grey list or the blacklist, and you become a high-risk third country for here. And essentially, what was it? Pakistan, I think, measured the cost of them being on the grey list. It was about 20 billion in trade they lost as a result of grey listing. So, there's significant pressure.
Yeah,
It just
yeah.
depends on how much pressure the other way America have over FATF to not get grey listed. So we'll sit on the sidelines and wait for that. I'm hoping that I'll build this, and much like the business in the UK, I am here. People keep coming to me at things going, "Have you moved?" I'm like, "No, I'm not moving. I've got Charlie and Daisy here, so we'll be going back and forth, but I'm very happy here." But the Teal business here, Emma, our COO, she runs the UK business here. In fact, she does, except she's in Australia this week with Rhiannon, settling her in there. But hopefully Australia will run itself, and then I'll be on a beach somewhere. That's where next.
Nice one. So we'll do episode 3, Amy on a beach, or Amy on the moon. We'll see what happens.
Time out from compliance and what's next we can do next time, but hopefully. I'm definitely around for the foreseeable, because bless Australia, I really hope that I can bring them.
It's going to keep you busy.
My 20 years worth of don't do it like that, and make it as easy and workable as possible. So that my work there is not nearly done.
I'm sure it sounds like there's a huge amount to do. Well, Amy, thank you so much for coming on the podcast again. It's been amazing having you, and there's so much insight and interesting stuff in there. So that was great. Thank you so much.
Thank you.
We really hope you enjoyed listening to today's podcast as much as we enjoyed recording it. If you did, please do us a huge favour and share it with a friend or a colleague. The more people we can get listening, the more time and energy we can get into recording more episodes and getting the best guests and the most interesting stories and insights. I want to say a huge thank you to the ICA for their support, to Ty and Karem here in the studio, and a massive thanks to Kat for making sure everything runs so smoothly behind the scenes. Don't forget to subscribe to the podcast, follow us on LinkedIn to make sure you never miss an episode. Thanks for listening.